أسعد الله صباحكم بكل خير. نستكمل هذا اليوم الثالث من جلسات مؤتمر القانون بالشرق الأوسط في دورته الثالثة. هذا اليوم نستكمل باقي الجلسات، ومن ثم عقد ورش العمل التي ستبدأ بالساعة 1، والتي أصبحت ورشتين، هي مكافحة الفساد في القضاء واستقلال السلطة القضائية. اليوم نستفتح الجلسة الأولى في اليوم الثالث، وهي بعنوان التحكيم وفض منازعات عقود الطاقة بالشرق الأوسط. يرأس هذه الجلسة معالي الأستاذ علي أبو دياك، وزير العدل بدولة فلسطين. علي أبو دياك كان رئيسا لمجلس إدارة المعهد القضائي، يحمل شهادة البكالوريوس في القانون بتقدير امتياز، وشهادة الماجستير في القانون من جامعة بريزيت في فلسطين. عضو نقابة المحامين الفلسطينيين منذ عام 1999. عمل معالي الأستاذ علي أبو دياك أمينا عاما لمجلس الوزراء بفلسطين، ومنح دكتوراه فخرية من معهد أوسلو في عام 2016. تفضلوا معالي الوزير لبدء أعمال هذه الجلسة.
السلام عليكم ورحمة الله وبركاته. معالي السيد مصطفى رميد، وزير العدل والحريات بالمملكة المغربية الشقيقة، حضرة المستشار محمد قديم، رئيس جمعية هيئات المحامين المغرب العربي، حضرة المستشار ماجد القاروب، رئيس المركز القانوني للتدريب في المملكة العربية السعودية، أصحاب المعالي والعطوفة والسعادة، السيدات والسادة الحضور، كل باسمه ولقبه. يشرفني أن أحييكم باسم فلسطين، وأن أنقل لكم تحيات شعبنا الفلسطيني، هذا الشعب الذي يناضل من أجل الحرية والحياة، من أجل الحق والعدل الذي يحميه القانون، من أجل الاستقلال، ومن أجل تحقيق الأمن والاستقرار والسلام العادل المشرف المبني على الشرعية الدولية والقانون. وأنقل لكم تحيات قيادتنا الفلسطينية، رئيس دولة فلسطين ورئيس الوزراء الفلسطيني والسلطة العدلية والقضائية في فلسطين. وأتقدم بالشكر الجزيل بكل الاحترام والتقدير للمملكة المغربية بتاريخها العريق وشعبها الأصيل وقيادتها الحكيمة وحكومتها الرشيدة. هذه الدولة بقيادة صاحب الجلالة محمد السادس، الذي جعل من هذه المملكة حصناً للحقوق والحريات ومنارة للتطوير والتحديث ومظلة للعدل والقانون. وأتقدم بالشكر أيضا للقائمين على تنظيم هذا المؤتمر الهام، والذين أتاحوا لنا فرصة المشاركة وفرصة رئاسة هذه الجلسة الهامة. هذا المؤتمر الذي حظي بالرعاية السامية لجلالة الملك لما له من أهمية كبيرة في تجسيد مناهج البحث القانوني وتوحيد المفاهيم القانونية وتعميق أواصر التعاون بين الدول، سواء على مستوى الوطن العربي أو الشرق الأوسط أو على مستوى العالم. وبما له من أهمية في مواصلة بناء أنظمة ديمقراطية يسودها العدل والقانون، وضمان الشفافية والنزاهة والحكم الرشيد، وصيانة الحقوق والحريات، وتحقيق الكرامة الإنسانية، وتجسيد سيادة القانون والنظام. وبهذه المناسبة يشرفني أن ألتقي هذه القامات العالية من وزراء العدل ومن رجال القضاء ومن خبراء القانون من كل العالم العربي ومن دول الشرق الأوسط ومن كل دول العالم، من حملة الأمانة والمسؤولية، حملة راية الحق والعدل والقانون، لنقف وإياكم هنا لنبرق رسالة واضحة للعالم أجمع، ونؤكد سويا بأن القانون هو أساس الحكم وميزان العدل ومعيار الحق والحرية والمساواة، ولا أحد فوق القانون، والكل يخضع للقانون، أفرادا وشعوبا ودولا وجماعات. نلتقي اليوم في مؤتمر القانون بالشرق الأوسط لنضع تحت الضوء مجموعة من المواضيع القانونية ذات الأهمية القصوى بالنسبة لجميع الدول في وطننا العربي وفي الشرق الأوسط وعلى مستوى العالم. هذه المواضيع التي تضع القواعد والمفاهيم التي يتناولها جدول أعمال هذا المؤتمر، والتي تركز على محاور متعددة من بينها التعليم والتدريب والتكوين القضائي والتقنيات وتكنولوجيا المعلومات ودورها في تطوير القضاء وحماية المحامين وحصانتهم أمام القضاء ودورهم في حفظ وضمان حقوق الإنسان. ويركز هذا المؤتمر على الوسائل البديلة لحل المنازعات وتنفيذ أحكام المحكمين والخبراء، كما يركز على حماية الاستثمارات الأجنبية في الشرق الأوسط والقانون والقضاء الرياضي وقضية الصحراء المغربية من منظور القانون الدولي والبعد الدولي لقضايا الإرهاب. نتناول في هذه الجلسة إحدى أهم القضايا القانونية المستحدثة، وهي التحكيم وفض النزاعات في مجال عقود الطاقة بالشرق الأوسط، حيث أن قطاع الطاقة يساهم بنسبة عالية في الناتج القومي الإجمالي، ويعتبر من أهم القضايا التي تلعب دورا هاما في تطوير ونمو الاقتصاد في كافة الدول ورفع مستوى المعيشة، حيث تحتل العقود التجارية في مجال الطاقة أهمية كبيرة في التعاملات التجارية والتبادل التجاري حول دول العالم. إن أهمية عقود الطاقة سواء عقود النفط أو الغاز الطبيعي أو الكهرباء وغيرها من مصادر الطاقة المتعددة تتطلب تأسيس منظومة قانونية لتنظيم العلاقة بين المنتجين والمستهلكين، وإيجاد آلية لحل المنازعات التي تنشأ عن هذه العقود، لما لها من أهمية في تنظيم العلاقة بين الدول والشركات الكبرى، وبما لها من دور كبير في تأمين الوسائل البديلة لحل المنازعات التي تنشأ عن هذه العقود ووضعها في إطارها القانوني السليم، باعتبارها منازعات تجارية عقدية طبيعية وليس لها أي أبعاد سياسية، ويجب ألا تتأثر في العلاقات السياسية والتطورات السياسية والإشكاليات السياسية بين الدول. ومثلما يساهم التحكيم في فض منازعات عقود الطاقة، فإنه يساهم أيضا في حفظ الأمن والسلم الدوليين بضمانه للعدالة وحفظه لمصالح كافة الأطراف المتعاقدة، وذلك لما تتمتع به هيئات التحكيم والمحكمين من خبرة وكفاءة ونزاهة وحيادية واستقلال، حيث لا تخضع هذه الهيئات لأي نفوذ أو سيطرة من أي طرف متعاقد. إننا نتطلع من خلال هذه الجلسة لإيجاد صيغ ووسائل قانونية عملية، وإيجاد وسائل غير تقليدية لحل المنازعات التجارية التي تنشأ عن عقود الطاقة بين الدول. ومن هنا فإننا نسعى لتأمين الضمانات للمستثمر تغنيه عن الانتظار الطويل لإجراءات التقاضي أمام المحاكم الوطنية والقوانين الداخلية التي تخضع لها العقود الداخلية في الدول. نأمل أن تكون هذه الجلسة بحضوركم الكريم ومشاركتكم الفاعلة منبرا يهدف إلى تعزيز اللجوء للمراكز الدولية للتوفيق والتحكيم والاعتماد على المحكمين والخبراء في الشرق الأوسط، كما نأمل أن يفضي هذا المؤتمر إلى توصيات هامة لإبرام اتفاقيات عربية وإقليمية ودولية لوضع تنظيم موحد للتحكيم في منازعات عقود الطاقة، تؤدي إلى ضمان حقوق كافة الأطراف والاتفاق على قواعد تنظيمية موحدة والمساهمة في حفظ الأمن والسلم الدوليين وتحقيق العدالة للجميع. ويسعدنا هنا أن نقدم لكم المتحدث الأول في هذه الجلسة، السيد جوناثان باركر، المحامي المجاز من لندن، والذي يتمتع بخبرات على المستوى الأوروبي والشرق الأوسط في مجال الإنشاءات والمقاولات والطاقة. فليتفضل.
Well, good morning, everybody. It's a pleasure to be in this wonderful country and at such a good venue. And I would like to thank Majid Group, who I've had a pleasure with working with for a number of years, for the opportunity to come here, and also to his team for all the hard work they've put into making this such a great success. Now, the topic of this talk is arbitration and alternative dispute resolution in energy contracts in the Middle East. What I would like to do, because we've heard a fair bit on arbitration so far, is try and expand that out to some of the other areas of alternative dispute resolution and look at some of the options that we can use there. So my small contribution will be touching on picking the right solutions for the issues that may arise and trying to do that early on at the contract drafting stages. And as an extension to that, I would like to have a look at particularly dispute resolution boards and how they might help resolve some of the issues that we commonly find in dispute resolution. So before getting to the heart of the matter that I'd like to talk about, it may be helpful if I can give some context to what we are looking at here. The energy sector can see many wide-ranging disputes, and they're often complex. They can be because of the size of the projects in the energy sector, the complexity and technical merit of the projects, often because of the large sums of money that are involved or the long lifespan of the projects. And then when we turn to the parties involved, we can have state versus state disputes, often over boundary disputes where gas or oil fields cross international borders. We can have company versus state disputes, for example, under a production sharing contract. Then there are company versus company disputes, which, in my experience, are the most common ones that arise. Now, these broadly fall into two categories. Firstly, there are disputes between joint venture members. For example, companies that have partnered in an operating contract or for a bid or study agreement. The second category for company versus company disputes is between contractors and subcontractors or operators. For example, transport agreements, processing agreements, drilling contracts, and the like. So with such a broad range of disputes, it is no surprise that one form of dispute resolution does not suit every instance. And this is where we get to the crucial point I would like to make in this talk. It is fundamentally important that when the contract is being drafted, the parties review the types of risk that might arise, the types of dispute that might arise, and draft dispute resolution clauses that are suitable for those circumstances. It is also the right time to ensure that the terms are those that the parties will be comfortable with. Now, this is something that arises at the risk assessment level in all forms of contract. We all do this. So, for example, with a transportation contract, we would have damages for late delivery. We would assign the risk to the party, to one of the parties for exchange rates where there's a multi-currency agreement. Yet we don't seem to give the same level of review to risks that arise in terms of disputes and how they can be resolved. And it's surprising because disputes are a risk in every form of contract, and there are things that can be done to minimise that risk. So what does this mean in a practical sense? Well, for example, the arbitration clauses can mean that parties aren't relying on local courts, which can often be attractive to foreign investors or parties who aren't from the country that is the subject matter of the contract. But even so, getting the arbitration clause right is crucial. Often parties will want to ensure that they're using established body rules so that there's familiarity with those. Parties will want to ensure that the seat of arbitration, which is very relevant to the enforceability of any arbitral award, is safe and, again, something they're comfortable with. Also, using bodies like the ICC can ensure that the process is managed by an independent body who ratify the award before it is given to ensure reliability of those awards. The arbitration clauses can govern other aspects. For example, how evidence is presented and how the case is managed. So if you have civil law lawyers and common law lawyers involved who are used to managing and displaying evidence in very different ways, running cases in very different ways, how that's going to be done can be settled in the contract itself. But equally important as the arbitration clauses in terms of providing for disputes are the alternative dispute resolution elements. Now, these can assist very well in keeping the contract moving, stopping late delivery, and the key point I want to make on that is stopping disagreements turning into full-blown disputes that might then have to go to arbitration. So let's imagine we have a contract for a processing plant, the assembly of a processing plant over a 4-year period. And late delivery is going to be extremely costly, as is normally the case. If a dispute arises that threatens that completion date, arbitration can, of course, find an answer to it. But by the time you have an arbitration award issued, all that's normally available is compensation. It cannot fix the issue at the time, because by the time you've been through the whole process, that's too late. So what other options are there? Well, contracts could provide multi-layered dispute clauses. So, for example, they could require that parties negotiate before resorting to arbitration. And that's useful, it's a good thing to do, but of course, negotiation doesn't always fix these problems. Equally, if they're not drafted right, I've seen negotiation clauses cause delays in resolving disputes because the parties hadn't followed the contractual negotiation process, and that meant they couldn't refer to arbitration even though there had been a level of negotiation first. So again, getting the clauses right, and what was required there was the ability by consent to waive the requirement to negotiate. Worldwide, mediation tends to be the favoured dispute resolution or alternative dispute resolution method between companies. Now, I believe mediation is very effective in the right circumstance. Also believe its popularity will continue to grow around the world. As I have mentioned, though, one type of dispute resolution is not necessarily the answer to every single situation. For example, for mediation to work, both parties must be prepared to compromise and give ground. And if they don't, mediation is likely to be a waste of time or money. I've also encountered, as an aside, a reluctance to mediate in the Middle East due to concerns about impartiality of mediators. I do honestly believe, though, that using established and reputable worldwide organisations like the ICC to nominate independent arbitrators and mediators and manages those processes go a long way to guaranteeing impartiality and reliability of these types of process. Now, the other form of dispute resolution I'd like to touch on, which I think answers some of these problems we see with the more conventional forms of dispute resolution, is dispute boards. So what are dispute boards? Well, they're a panel which can sit full or part-time. If they're sitting part-time, what will happen is when a disagreement arises, they will be called upon to look at that and deal with it. Full-time boards are the ones I've seen being most effective because they will work throughout the course of the contract and attend meetings. What that means is they are always familiar with the process, they're familiar with the parties, and they know what's going on. What then happens if a disagreement arises, they help fix that before it turns into a full-blown dispute. And going back to my example with the processing plant, it's often more desirable to keep the project working and keep the parties moving rather than resort to arbitration where one party could be wrong about their rights and find themselves a couple of years down the line in a much worse position than they'd hoped they'd be. Dispute boards tend to be much faster and less expensive than arbitration or litigation. And they're good at keeping projects moving. So how do the dispute boards work? Well, panel members are normally one or three. Parties can select that at the commencement of the contract. FIDIC contracts, for example, recommend a 3-member dispute board for contracts exceeding $25 million in value. A dispute board issues a decision. A lot of processes require that within 28 days, for example, ICC and FIDIC contracts. And the dispute decision has a binding effect on the parties unless or it is until it is resolved by amicable settlement or arbitral award. Now, use in Middle Eastern countries hasn't been pronounced as in some other parts of the world, and likewise, less so in places like the energy sector than in the construction sector, where dispute boards have been taken up very well and are proving very effective. One word of warning there in terms of the contract drafting: where you've got something like a FIDIC contract, you can find that if it provides for a dispute board and you leave those terms in, you can then be obliged to follow the dispute board process. For example, Article 265 of the United Arab Emirates Civil Code provides that where terms of a contract are clear, parties cannot depart from them. And I've seen situations arise where parties didn't want to run a dispute board process, but were bound because they hadn't struck that out of the contract. So dispute boards can be very successful in dealing with issues as they arise. And this is really the core of what I was getting to in this talk. They can be effective before relationships between parties are damaged beyond repair. Now, that can be fundamentally important, let's say, in the second year of a 10-year contract, where arbitration, as I say, can, if things turn into a dispute, find a remedy, but it's not necessarily one that's conducive to a good relationship and an ongoing relationship. Most common criticism I see with dispute boards is over the cost. And that's a fair point to a degree. Full-time dispute boards are perhaps not ideal for small contracts, although single-member part-time boards can be effective there. But the time and money they can save in a long contract where the ongoing relationship of the parties is fundamentally important often way exceeds the cost that they impose. So going back to my examples, the types of disputes that arise and a few examples of what types of dispute resolution clauses we might look at. If you've got a joint venture for a processing plant and it's over a number of years, of course, it's crucial that those parties' relationships keep working. And to rely just on arbitration to deal with any disagreements that may arise risks fundamentally falling out in a way that's irreparable. And it's areas like that that dispute boards work very well. In other areas, I mentioned drilling contracts and similar sorts of technical contracts where technical disputes arise. Expert determination is often a good example, a good alternative dispute resolution that is fast, it is effective, it's reliable, and it deals well with those sorts of technical issues that arise. Having said all of this, arbitration will always have its place at the end of these processes. And the point, if I can summarise that I wanted to make in this talk, is when we're looking at the contracts, assess the risks of what kind of disputes might arise, have a look at the effects they might have, and think at that point about what forms of alternative dispute resolution might best protect against those, and try and agree between the parties how they operate. And when doing so, I would encourage people to think more about dispute boards and how they might work. So I'll leave my talk there and say thank you very much for listening to me. Thank you.
نشكر السيد جوناثان باركر على هذه المحاضرة الهامة، وننتقل للسيد ستيفن هاموند، خريج جامعة باوندن كلية القانون مع مرتبة الشرف، رئيس فخري للاتحاد الدولي للمحامين، عضو الجمعية الأمريكية للمحامين، وعضو غرفة التحكيم الدولية ICC، خبير في التحكيم التجاري الدولي، ويتناول العديد من القضايا من خلال مكتبه بنيويورك. فليتفضل مشكورا.
Thank you, Mr. Chairman. Good morning. Let me begin by joining in the early comments of many of our previous speakers and our chairman today on the importance of peace and understanding among peoples in the development of the rule of law. And in that spirit, thank the organizers of this conference for providing so many of us from outside the region the platform and opportunity to join you here today in that very, very spirit. I see my role as follows. After so many detailed and excellent presentations on specific areas of arbitration, international arbitration generally, and now, as of this morning, on energy arbitration, I hope to dissect, really, the problem, because the organizers have pointed out to me that there are many members of the local judiciary who are here with us this week. And one of the aspects of international arbitration that we don't, as practitioners, tend to think about enough is the key importance of the intersection between the various legal systems, whether it's the private system of justice that we call arbitration, or the semi-private system between states and investors that we refer to as treaty arbitrations. Really, arbitration depends on the local courts, and I wanted to make sure that we spent a few minutes at the beginning of my remarks today to review those principes de base, as our French colleagues would call them, in dissecting international energy arbitration. So what are we talking about? As our colleague Mr. Parker told us, we're talking about a consensual arrangement, which really is born out of the freedom to contract. And of course, the freedom to contract is part and parcel of a local legal system. So already from the get-go, from the very first step, we have to view arbitration in the broader context of a system of justice. But what is special about arbitration is that because it is a creature of consent and of contract, the parties, as we have heard, are totally free to design whatever system or to choose from whatever institution those mechanisms that they think will be best suited to their dispute. This really is of key importance, the flexibility of the process. And certainly as we turn to the specifics of international energy arbitration, we're going to see this emerging notion that just as historically in the commercial law, there has developed outside of the restrictions of national legal systems notions of lex mercatoria, there has evolved in the international sphere custom, practice, sometimes reduced to institutional rules, but in essence, what is generally considered to be best practices for private dispute resolution. And in the end, that's what we're going to have to get our hands around if we're going to understand this animal that we've characterized as international energy arbitration. But as I said before, the most important aspect, I think, to keep in mind, and this is extremely important for our colleagues from the judiciary here, is this essential dynamic between delocalized or private arbitration and public judiciaries, local systems of justice. It happens in the beginning because if one party to this agreement is unwilling to abide by its terms, to live up to its terms, then you may well have to resort to the local courts to get the arbitration agreement enforced. If there are urgent measures that need to be taken in certain systems, it may depend on local judges to assist, if you will, the private system of justice by hearing the parties on provisional remedies and measures. And ultimately, as we will see, one of the key aspects of international arbitral practice is its broad enforceability. In fact, just as we have reserve currencies in the economy, it can be said that to a certain extent, the best international currency, if you will, in dispute resolution is the arbitral award. We heard a little bit about, in fact, we heard quite a bit about this yesterday in the context of our friends and colleagues' extended discussion of enforcement, but I just wanted to complement his presentation with these statistics for you to give you some broader understanding. The international conventions that really deal with enforcement of arbitrations include the New York Convention that you've heard talked about quite a bit, of which 156 nations are now parties, and so have by treaty, as we heard yesterday, committed themselves to enforce in all but the most limited circumstances arbitral awards rendered as a result of this private system of justice. In my hemisphere, the Western Hemisphere, there's also a convention among many of the Latin American and North American states, the Panama Convention, which does essentially the same thing. Although I'm not going to talk about it today when it comes to the quasi-private, quasi-public disputes between sovereign states and private investors, the Washington Convention, which created the International Center for the Settlement of Investment Disputes, ICSID, now enjoys the support of 159 nations. So once you go through the process, you reduce your rights to an arbitral award, you of course then have to turn once again to the local judiciaries in these hundreds of countries in order to enforce your rights. So we see that throughout, the role of the judiciary is fundamental to the success of this private rule of law. In fact, we can contrast it with the fact that in most countries, states are not parties to convention, at least yet, not parties to treaties on the enforcement of judgments, at least outside of Europe. So we've already heard through Mr. Parker many of these points. Let me just throw up the screen and make sure that you can see it. I guess, is that the enforceability screen? I'm having some difficulty seeing it. Let me advance it to this. Arbitration is a process that is based in the notion of delocalization, international arbitration, I should say. If a French company wants to conduct business in India, it may well be reluctant to have hundreds of millions of dollars it's put at risk subjected to resolution by a provincial judge in India. In fact, our colleagues in the bar in India often joke that in choosing an Indian lawyer, the most important qualification is his age, because a foreign company must always choose the youngest lawyer he can find in order to have some chance that he'll still be alive when the courts finally decide the dispute. So we have this aspect of delocalization. We have multicultural environments with arbitrators from different nationalities because, as we know, commerce is multinational now, and it is often common to have these disputes resolved by 3 arbitrators from 3 different countries. There is a very important aspect of this, which I thought our judges might find interesting. In a 3-person arbitral panel, typically each party chooses one of the arbitrators. And in many traditions, legal environments, including my own, it's almost expected that the party-appointed arbitrator will be in contact with counsel when it comes to selection of the chair. Both sides know this. They both have an even playing ground. So, in essence, as we like to tell our clients, they almost are appointing 1.5 members of the 3-man tribunal. Of course, it's no different from the other side, but it does help to convey a sense of being invested in the process. We spend a huge amount of time making sure that we find the right arbitrator for the right dispute, just as at the contracting stage, we spend a lot of time, as our colleague Mr. Parker indicated, in making sure we have the right arbitration clause. They're both fundamental to the process. Also, arbitration, unlike most local judicial systems of resolution, typically has quasi-finality at the first instance. And in a world of fast-paced business, businessmen put a lot of importance on knowing that their disputes will be resolved up or down in a much more speedy manner. Again, India is a good contrast. We've already spoken about enforcement. I won't go back to that. There is another panel I hope that we'll have time to talk to you about just how important it is to get the right terms in your arbitration provision. In fact, our esteemed colleague from the Morocco Court of Appeals yesterday raised a question about one of the comments of the speakers that related to traps in arbitration. And I would submit to you that one of the biggest traps, we're going to be speaking about a couple of them, but one of the biggest traps is what we refer to as the pathological arbitration clause, where parties who are a little less used to dealing with this problem draft clauses which are either impractical or unbalanced. So I've put out here for your use sort of a short checklist in going through the drafting process, because, as we said before, we're talking about a private system of justice that is consensually based. If we don't get the clause compromissoire correct, the arbitration clause correct, we're going to have tremendous difficulty. So let me just then turn to the separate species of international energy arbitration or international oil and gas arbitration. I've put up for you here an extract from a prominent practitioner in the area because I thought it interesting to note that he starts his reflection on these issues by saying that some, and I might even say many, international arbitration specialists would argue that international oil and gas arbitration is not a separate legal discipline. You may have construction arbitration, energy arbitration, financial arbitration, but they're all very, very close first cousins. But as I said, we're really talking about best practices, customs that have developed over time. And as Mr. Gatiss, the author, concludes in this quote, there has been considerable movement toward recognizing oil and gas arbitration, or at least its broader cousin, international energy arbitration, as a separate discipline. So that's where we're going to focus our attention today and pick up on some of the comments of Mr. Parker a few moments ago. As another author has pointed out, in giving the industry perspective on energy arbitration, he says that in the oil and gas industry, disputes are inevitable. The size and complexity of the projects involved, the political factors in play, and the increasing technical complexity and risk mean that a lot can and does go wrong. In addition, cyclical product prices put contracts, projects, and relationships under strain, and in the upstream sector, it is common for disputes to arise among joint venture partners, investors, and their contractors. Disputes between energy companies and host states can arise in both the upstream and the downstream sectors. Mr. Parker's already taken an initial look at how to get your hands around these concepts. I guess as somebody who started life as a journalist, I would suggest to you that in my country, at least, English-speaking journalists often turn to what they call as the 5 W's whenever they do an article. And it's one way to help us orient our thinking here. They ask who, what, when, where, why. And as you saw from that last quote, really who is involved may help us understand from the beginning, and as Mr. Parker told us, the different who's, the different players, often point us in different directions about slightly different varieties of what we might overall refer to as international energy arbitration. Here you've got my simplistic attempt at breaking down the who part of the problem. You have the resource owners, states and state-owned enterprises, their licensees, investors, or both, and their assignees. Because, you know, the world is a complex place. So even after there is a concession by the state or a license granted for an oil field, as we've heard from Jonathan, there are joint ventures, multiple actors that come in through consortia, whether it's in the construction process, in the operating process, and indeed in sort of the financial process. Once everything is up and running, we'll speak in a moment about how interests get acquired and companies get bought and sold. And at each step of this highly complicated and high-dollar series of commercial transactions, things can, and as we heard, often do, go wrong. As Jonathan mentioned, we can look at the level of operators and their consortia. We can look down a further level at subcontractors and service providers. And I guess the only actor that I would add, which I guess Jonathan did make allusion to, is institutional actors, by which I mean not just, for example, the ICC and other institutions of the like, but also some of the trade organizations. I put up a slide from another commentator here to help you see quickly, if you can read it, how he organizes oil and gas projects and sort of points to the key role of FIDIC that Jonathan referred to, the International Federation of Consulting Engineers, who have published a series of books that many of you are familiar with of various colors, the Silver Book being the one perhaps most important in the area of international construction arbitration, certainly in mega projects. And they have adopted as their best practices from the Chinese menu of various mechanisms a series of stepped dispute resolution processes, which begin with an ad hoc dispute adjudication board, perhaps, as Jonathan referred to, and then if either party is dissatisfied with the decision of the dispute board, then they can seek to settle the dispute through negotiation. And then ultimately, of course, if that's unsuccessful, in the case of the FIDIC contracts, the form contracts, the matter is referred to ICC arbitration. So FIDIC is obviously having an important role in institutionalizing this customary lex mercatoria, if you will, or lex disputoria, whatever the Latin would be, of how private disputes are resolved. The authors of this treatise then look to the Association of International Petroleum Negotiators, who have their own model contracts in terms of joint operating agreements. And as you'll see here, they have a slightly different approach, but again, it's a first cousin with a different selection, a different emphasis of the various ADR mechanisms. The authors went on to talk about the mining sector. I put it here just again to show you that there's another trade group, not to really get bogged down in the actual details of the dispute resolution process. So again, this moves us towards the what. It's not just who the actors are that are going to give rise to various classes of disputes, but what they're up to. It's going to, again, give us a separate dimension by which to approach international energy arbitration. As these authors point out, arbitration is the dispute resolution mechanism of choice in the energy sector. Parties regularly include arbitration clauses in joint venture agreements, joint operating agreements, production sharing contracts, construction contracts, commodity export contracts, and then they take one example from the Association of International Petroleum Negotiators and list a whole series of subcategories of agreements, from study and bid group agreements to gas transfer agreements and all of the way stations in between, where again there has been an attempt by industry groups to help bring some cohesiveness to the best practices in international energy arbitration. Indeed, New York, where I practice, is a very important financial center, so we often see in the acquisition space disputes that arise when one party buys out another's energy business or energy activities. And I've stolen these slides from an earlier presentation last year, which I captioned "Arbitrating in a Trigger-Happy World," because we increasingly see that post-closing disputes in which one party brings a claim against the other party for price adjustments after the fact are almost the norm instead of the exception. And in that particular talk, I cataloged a whole series of articles in my own country where each state, when the courts again become involved at the enforcement stage, and in developing the commercial law, each state has a different rule in the context of what we refer to as sandbagging. Sandbagging is a curious concept. It's when someone buys...
We have 2 minutes, please.
Okay. When a party has to do due diligence and becomes aware of a fact that has been disclosed by the seller, but ultimately sues the seller later on, in essence sandbags the seller. Well, in light of the shortness of time, let me skip through these next slides. I had here a series of slides to list the various mechanisms to make sure that you were clear about the difference between mediation and conciliation and so forth. We won't have the time to go through that, but I would point out that negotiation is in fact really the first on the list, because even without the intervention of any kind of system, we still have alternative dispute resolution. Let me close with a quote from a great lover of the desert, Antoine Saint-Exupéry, who said that experience will guide us to the rules. You can't make rules precede practical experience. In English, we talk about up-down, bottom-up, or top-down. In many ways, a local court system is a top-down system of rules. But in the spirit of Saint-Exupéry, international arbitration is really based on practicalities, it's based on practice, and the parties are able to develop from the bottom up a system of institutions and rules in order to resolve as a matter of private justice their disputes. Thank you for your attention.
شكرا سيد ستيفن هاموند على هذه المحاضرة الهامة. فهو خبير في التحكيم، وطبعا محاضرته تطول، ولكن يداهمنا الوقت ولم يعد هناك مجال كما كان مقررا في البرنامج للمداخلات والأسئلة، ما عدا إذا كان من الممكن أن نأخذ 5 دقائق الأخيرة أو 10 دقائق يا سيدي للمداخلات والأسئلة للخبراء.
شكرا جزيلا. ما أعرف أقولها بالإنجليزي ولا بالعربي، لكن this is the single most important issue in terms of economy, politics and geopolitics in the Middle East and Africa. And I want to compliment a very wonderful presentations by adding some policy dimensions situations. The Middle East is the biggest producer of energy. And in fact, we have one country, Saudi Arabia, it's the biggest producer. It also represents 25% of the Arab League economy. The 3 geopolitical factors affecting disputes in the energy sector now. واحد, the drop or the fall of the oil price. This is definitely bound to increase the volume of disputes. اثنين, political instability في Middle East and Africa, to the extent that some of the oil facilities are occupied by non-state actors زي داعش وليبيا، في حركات مسلحة تستولى على مصادر الإنتاج. والفاكتور الثالث هو الشيل برودكشن. الشيل برودكشن in the United States and other countries, which is now causing oversupply to the market, to the extent that prices are not expected to go back to where they were a few months ago. To this extent, the region is going to suffer from an increasing trend of energy disputes. We now know that at least 43%, أقل حاجة 43%, 43% of the disputes are actually in the energy sector. This is going to cause some distress to some producing countries, where contracts have to be revisited, renegotiated, or terminated altogether. We will see invocation of force majeure, for example, or any variation and clauses. And I want to invite an insight of experts on this particular area. What do you expect the disputes in the energy sector in the region to be? The very future, the very eminent trends in terms of the type of state to investor disputes that we are seeing, because the energy sector is also affected by very important issues such as state succession. For example, in Sudan and South Sudan, the resultant outcome is that the South Sudan ended up having 80% of the oil facilities in the country. Kurdistan, Iraq have their own production sharing contract models and whatever, and this is of course expected to be another state succession situation. So we are going to see very dangerous, very dynamic geopolitical trends coming in this very important area, to these very important sectors. I really need some insight in this. Thank you.
Well, thank you very much for your question. I think at the end of the day, you mentioned you had 3 points. I have 2 to address. I'm not sure I got the third. But certainly when it comes to price fluctuation, what you're really doing is pointing to us the importance of international arbitral mechanisms.